All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good morning, y'all. Welcome to your North Carolina Court of Appeals. My name is Chris Dillon. I'll be presiding today. To my right is Judge Jeff Carpenter, and to my left is Judge Fred Gore. We have one case for live argument today. It is Cryan versus National Council of the YMCA. And so if the appellants are ready, you can begin. And let me know if you'd like to reserve some time for rebuttal. And I usually just kind of keep it by the clock, so don't let and I'll give you your warnings, because if we're firing questions at you and stuff, don't worry about the lights so much.
Thank you, Judge Dillon, and may it please the court. I'm Lauren Lapidus with Nelson Mullins for the defendant appellant, Kernersville YMCA, and with the court's permission, I would like to reserve 5 minutes for rebuttal. The issue on appeal today is as follows: whether the Forsyth County Superior Court erred by concluding that the Kernersville YMCA raised a facial constitutional challenge to certain provisions of the North Carolina Safe Child Act and thereby mandatorily transferred venue of the action before a 3-judge panel in Wake County for disposition pursuant to a controlling trinity of statutes. Now, determining whether a constitutional challenge is facial or as applied requires the exercise of judicial restraint. And that's a concept time immemorial, from early in the Republic back to the Federalist Papers, when Hamilton explained that court should exercise not force but judgment. And that's what we're asking from the court here. The trouble was down below at the trial court, that guiding principle of judicial restraint was upset for 2 reasons. That court below in Forsyth County re-engineered the Kernersville YMCA's squarely presented as applied constitutional challenge in its 12b6 motion to dismiss into a facial challenge that didn't exist, and thereby mandatorily transferred venue of the entire action below to a 3-judge panel.
Now, what class of people would you contend would this statute not be unconstitutional for? So if you're making it as applied, there must be some class of people where it would be constitutional. So what would those class of people be?
Yes, Judge Dillon, and that class of people are those for whom the existing statute of limitations and repose had not expired at the time that the SAFE Act took effect on 12/1 of 2019. So in other words, if a prospective plaintiff was under 21 at the time that the SAFE Act was passed on 12/1 of 19, the existing limitation and repose periods were still open. And therefore, that could constitutionally be applied, and that's a separate case for a separate determination before a later judge and a later appellate panel. But what we're asking for today is an as-applied challenge with respect to our client, Kernersville YMCA, who raised an as-applied challenge in a motion to dismiss only with respect to these 9 plaintiffs and this defendant that we represent.
And there's no issue of fact that the old statute had already expired as with respect to these 9 other plaintiffs.
That's correct, Judge Dillon. And in fact, that's conclusively established on the face of the complaint. And that's why our 12b6 motion essentially raises an affirmative defense as a bar as a matter of law. And I think that's undisputed on this record. So our client raises the applied challenge because at the time that the SAFE Act took effect, our statute of limitation and repose had already run, and therefore rights had vested under the North Carolina Constitution. And this idea that you're talking about of construing challenges properly as applied challenges. And
what rights vested under the Constitution?
Due process rights under Article 1, Section 17 of the North Carolina.
To not be sued?
To be free from revived civil exposure.
Right. The legislature sets what those statutes of limitations are. That's not constitutional. You'll concede that.
Correct. As long as the statute of limitations is open and it hasn't run, then future legislation, Judge Carpenter, can extend that statute of limitations into the future. But the North Carolina Constitution comes into effect when you have a statute of limitations that's already run at the time that the new legislation is passed, and the Kernersville YMCA's rights to be free from revived civil exposure had vested under the Constitution. And that's the nature of our applied challenge, which is a merits determination that's not before this panel. All the issue that's before the panel is did the Kernersville YMCA raise a facial constitutional challenge or an as-applied constitutional challenge, and whether venue belongs back in the Superior Court of Forsyth County before a single Superior Court judge or before a three-judge panel. But
Well, the three-judge panel only, assuming that it is a facial constitutional challenge and it's properly transferred, the three-judge panel only has jurisdiction to hear the constitutional challenge, not the remainder of the case. You'll concede that, I hope.
I think by statute, I agree with your general premise, Judge Carpenter, but I take issue with the idea of jurisdiction, and I think that's an important issue here, because I think what you're liable to hear from our friends on the other side is that this is a question of jurisdiction and not venue. But I think the point here is that we don't seek review on jurisdictional grounds. Judge Gottlieb in Forsyth County, we're not contending that he lacked jurisdiction to enter the order that he did.
No, Judge Gottlieb, that's where the case was brought.
Correct.
My question to you is, how does, assuming that it is a facial constitutional challenge, how does the three-judge panel have jurisdiction to address anything other than the constitutional
It
issue?
doesn't have authority to deal with anything else, assuming that's true.
But doesn't Rule 42 allow the judge to decline to rule on the other 12B6 issues and let the three-judge panel decide those issues as well?
I don't think that's the correct reading of Rule 42 and the Holdstock opinion for these reasons. When Holdstock was decided, there were certain enumerated pleadings that qualify as properly raised facial challenges that are permissible to be transferred to a three-judge panel. And a 12B6 motion isn't one of them. And the same language in Rule 42b-4 that we have today was before the Holdstock panel as well. And despite that language, they concluded that only certain pleadings, and they are complaints, amended complaints, answers, responsive pleadings, and other court papers filed 30 days after an answer. But I think the point here is that there is language in Rule 42b-4 about a 12b motion, but that's presuming there's a properly raised constitutional challenge in the first instance.
Well, I understand that. So if there's a proper facial challenge, can't the trial court judge just decline to rule on the rest of the 12B6 and let the three-judge panel? That was my question.
Yes.
So they do have, if there's a properly raised challenge, then the three-judge panel does have discretion to consider those other matters that Rule 42b talks about.
But I think that the...
But your whole argument is that there was no facial challenge made.
That's correct.
Okay.
That's correct. You know, and I think the idea of judicial restraint is to construe challenges whenever possible to be as-applied challenges, because when a court construes a challenge as a facial challenge, that really short-circuits the democratic process. And why? Because every time the judiciary tees up a facial challenge for disposition, then it wipes away all applications that could constitutionally apply potentially in future cases. And that upsets the General Assembly's prerogative to legislate. And that really goes against our common law tradition of dealing with cases on a case-by-case basis on the specific facts and issues in each case. But I think here, and I haven't seen anything in our briefing from our friends on the other side about how this challenge is a facial one. I think they talk about how we might attack certain provisions of the statute, but that's not the test. The test for an as-applied challenge versus a facial challenge is, are we contending there are no constitutional applications available? And that is absolutely what we're not contending. We are saying on this 12b-6 between these parties, because our vested rights, the Kernersville YMCA's vested rights already accrued. They vested at the time that the SAFE Act took effect, the Constitution bars, because all these plaintiffs were over age 21. But for everybody that's under age 21, that's a separate case. That's a different constitutional application for another day.
So, counsel, what part of your motion can you point to that provides some clarity to as applied versus facial?
Well, I think I would point the court to record page 89 and 90 and 91. Specifically, paragraph 2 on page 90, where we're saying in this case the General Assembly's amendments to the statutes at issue, primarily 117A, are unconstitutional only as applied to the Kernersville YMCA on the particular facts of this case, because they contravene fundamental state substantive due process grounds. And as alleged on the facts of this particular case, you have to look at the complaint in conjunction with the motion, and the complaint conclusively establishes that all of the existing statutes had already run. And then in paragraph 3 in our motion to dismiss, we say specifically under these portions of the North Carolina Constitution, the Kernersville YMCA has a vested constitutional right to freedom from civil liability after the existing statutory limitation or repose period on claims has already expired. And Judge Gore, that's the key, after. We're not contending what happens in cases when the existing statute of limitation and repose periods had not expired, because that could be a constitutional application for a different case. But that's not what we're moving for.
Isn't it fair, though, and I appreciate you bringing to the exact paragraph, but isn't it fair that there could be a scenario where they have run and still there is a facial challenge to the constitutional argument?
Well, I would leave that to a different counsel for a different day. I can only tell you what we've done here in this case with respect to our as applied challenge, because we want to honor that principle of judicial restraint and honor the common law tradition that this state has to deal with cases on a case-by-case basis and not try to wipe away the entire statute, the entire legislative prerogative by one foul swoop of a judicial opinion. That's just not the way that I think that, the founders recognize that we should handle constitutional challenges. So because there's no statutory basis under the trinity of controlling statutes to have determined there's a facial challenge and therefore a mandatory venue transfer under this trinity of controlling statutes, we'd ask that this court reverse and remand the case back to Forsyth County for disposition of the 12B6 motion before a single Superior Court judge, which is where venue appropriately lies.
So the issue of whether this statute is unconstitutional as applied, that issue itself is not before us. It's just whether or not the trial court judge should have ruled on that particular.
Absolutely, Judge Dillon. That's the narrow issue before this panel today. And I'd like to address the issue of appellate jurisdiction, because I think there are some issues that our friends on the other side have brought up that are worthy of mention. The Kernersville YMCA's appeal of the trial court's mandatory venue transfer order is immediately appealable under the substantial right test, because the order below granted plaintiff's motion to transfer, which asserted a statutory right to venue under the North Carolina Supreme Court's opinion in Gardner v. Gardner and its progeny as developed here. That venue order is immediately appealable because the trial court's conclusion that the Kernersville Y raised a facial challenge triggered a mandatory venue transfer under GS 1-81.1 to the three-judge panel. And Judge Dillon, I believe you authored this court's published opinion in A&D Environmental Services versus Miller, and in that case that expressly recognized the Gardner doctrine, and it said orders that affect people's rights to have their cases heard in the proper venue are immediately.
So my question is this: if the trial court judge had only transferred the facial challenge, and you're arguing that you haven't made a facial challenge, and I don't know what substantial right has been lost, if you can argue the rest of your motion in Forsyth County. But as I understand, do you interpret the trial court judge's ruling as he's transferring the entire 12B6, all your issues, to the three-judge panel?
I think the court is constrained to do that because, as cited in our brief, this court's precedent recognized that we have to give respect to the textual command of the order, and the order transfers this action. It doesn't transfer the 12B6 motion. But our substantial right analysis would
What authority does Judge Gottlieb have to transfer the action to a three-judge panel on a facial constitutional challenge? That's what the order says, that it's a facial constitutional challenge. He made that determination. That's the issue, whether it is or not. But what's the jurisdiction of Judge Gottlieb to transfer the action in its entirety under a transfer pursuant to these statutes?
There's no statutory mandate to do that, Judge Carpenter. And
There's no statutory authority to do that.
Correct. And I think also, Judge Dillon, that our substantial right analysis would be the same if only a portion of the action were transferred or the entire action were transferred. Because the Supreme Court, in the Gardner case, has language that's just worthy of briefly citing. It's very short, but it's also very poignant. And what the Supreme Court has said in Gardner is that although the initial question of venue is a procedural one, there can be no doubt that a right to venue established by statute is a substantial one. Now,
How are you deprived of venue? That's the question.
Sure.
That I'm asking.
We're deprived of venue because the case never left the General Court of Justice Superior Court Division where it was filed. This court has defined subject matter jurisdiction as the power of a court to deal with the action before it. But this action was filed in and remains in the Superior Court General Court of Justice Judge Gottlieb's order is a mandatory venue determination because what he has concluded is that Forsyth County is not the proper county within the Superior Court division to hear the challenge.
Help me with your logic on that in light of the specific wording of the statute, specifically that Judge Gottlieb found that it was a facial challenge which requires transfer. Help me with the logic. I'm having trouble following the logic that Judge Gottlieb has transferred the entire action and not just the constitutional issue.
Well, that's based on the plain language of the order. But even if he only transferred...
Will you concede that Judge Gottlieb can't do what the law doesn't allow?
Oh, well, he can't.
Okay.
But even if he transferred just the 12b6 motion, it's not a facial challenge. It's not a properly raised facial challenge, never was. And the substantial right analysis applies nonetheless because Gardner doesn't say, well, if you transfer a portion of the case, then that isn't a venue issue, but if you transfer the whole thing, then that is. But Judge Gottlieb simply concluded, made a venue determination because one county is not the proper, legally correct place for the case to be decided. He moved it to Wake County, which is another place within the General Court of Justice. It never left that venue. It never left the jurisdiction, rather, of that court. And 1-81.1 is the venue statute. And the Supreme Court in Stevenson versus Bartlett confirmed that it's a venue statute. And that's the issue we're dealing with, not a jurisdictional one. Because we are not contending that Judge Gottlieb of the Forsyth County Superior Court lacked subject matter jurisdiction to have entered that order. All the substantial rights cases that our friends on the other side are relying on say, okay, we're going to try an immediate appeal, but we're going to argue that the trial court lacked jurisdiction to do what it did. But what we're saying is that Judge Gottlieb sent it to the wrong place within the court system. That
So I want to, if I file a 12b6 motion, I can have a lot of theories. One of them could be a facial challenge. If I make a facial challenge, if I don't make a facial challenge, I have the substantial right to have that whole 12b6 decided in that county. That's the venue. The court can't just transfer it to another county. If I make a facial challenge, as I understand Rule 42, then a three-judge panel could be proper venue for all my 12b6 under Rule 42. Isn't that correct?
I don't think that's right. I think that under Rule 42, you have to have a properly raised...
That's what I said. No, if I made a facial challenge, then it's a proper... Then my entire 12b6 would be... the venue for the rest of it could be in the same county if the trial court judge wants to, or the trial court judge says, I don't want to mess with any of it, and they could transfer venue.
I think that's correct.
So your substantial right you're arguing is you have the right to have your as-applied challenge argued in Forsyth County because you didn't make a facial challenge.
Correct.
Okay, I'll just make sure I clarify that.
That's correct. And it's a venue issue, not a jurisdictional argument for those reasons, because we're not arguing about jurisdiction, but we're arguing about the place for decision of the case, which is the definition of venue. And I think, though, that there's a concession in the brief as well that of the appellee that, hey, if you have disposition of a motion asserting a statutory right to venue, which is what we have here, then you get an immediate appeal. I think their contention is, well, it's a discretionary venue transfer order, not a mandatory venue transfer order. But you definitely have a mandatory order by just looking at the text of it. I mean, it concludes that it's a challenge properly raised under 42b4, which of course we take issue with, on the merits of the decision. But if the trial court concludes under Holdstock that it's a Rule 42b4 challenge, then the court has no discretion. It has to transfer it. And that's the language that's used in the order, which is he must transfer it. It must be transferred.
Well, this would be a pushback. You filed your motion. No, you made your defenses, and you say you made an as-applied challenge. They make a motion, and their motion clearly says, we want to transfer this for appointment of a three-judge panel to determine the facial constitutional challenge, which they can do if you made one.
If we made one.
Okay. The trial court judge's order, if you make a facial challenge, can transfer the rest of the 12b6 there if the trial court judge declines or makes that determination. And I'm trying to interpret the trial court judge's order on page 124. It does says, in light of the court's ruling herein, the court makes no ruling on the defendant's motion to dismiss. And I'm trying to interpret that. Does that mean that the trial court judge is basically saying, I'm never going to rule on the rest of your theories, I'm transferring all that to the three-judge panel? or none of the other theories are before me because the only theory that the plaintiff moved for was a facial challenge. I mean, so what, I'm trying to interpret this order. I mean, my question I'll ask the appellee is, does Forsyth County still have they retained the venue to decide the other motion to dismiss issues?
I don't think so, based on the language of the order transferring the entire action, which is one of the problems.
Okay.
It didn't just transfer the 12B6 motion, which we say you can't do anyway because that's not a properly raised
Okay.
facial challenge, even if you assume it's a facial challenge.
That's a good point. I see that. Okay.
But, and that's talked about in Holdstock at length.
Because I would contend that if the trial court judge only transferred this mythical facial challenge to the three-judge panel, you haven't lost a substantial right, because what is lost? You can still argue the motions you claim that you've only made, or your only theories in Forsyth County, because the trial court judge hadn't transferred that. But you're interpreting the order to say that the trial court judge has transferred all the theories to the three-judge panel on your 12B6 motion.
Yeah, yes, Your Honor, and that's based on the text of the order and this court's controlling authority that requires the court's written order to be controlling, not any oral statements or what the court would like for the order to have said or otherwise. But even if the trial court did transfer just the 12B6 motion, under Gardner and under this court's substantial rights cases, there is still a substantial right to have that venue determination heard in the correct place. Because the Desmarais case that we cited in our brief talks about how it can't be tweaked later down the road. It's got to be fixed now. And that's the deprivation of a substantial right.
Isn't the venue decided by the allegations set forth in the complaint when it's filed? Isn't that what the guiding facts that the trial judge leans upon in determining whether venue is proper?
I think, Judge Carpenter, that's ordinarily the case. But here, it wasn't the defendant that moved for a venue transfer. Venue was fine when the case was filed because there was no constitutional challenge yet made.
Yeah, but the argument you're making is venue is a substantial right, and because venue has been changed, assuming your argument is correct, because venue has been changed, the defendant, the question is, who's it a substantial right for? Is it not the plaintiff as it's established by the complaint?
Well, I think it's the defendant and the plaintiff, and that has to do, I think, with what the Supreme Court has said in Gardner v. Gardner. And what Gardner v. Gardner says is that there's no doubt a right to venue established by statute is a substantial right. Its grant or denial is immediately appealable. So the Supreme Court is saying is that goes both ways to both parties. Whichever way the trial court rules on venue, if it's granted is a substantial right, its denial is a substantial right.
How does the new statute, Gardner was decided in 1980.
Yes.
How does the new statute affect that holding by the Supreme Court?
Well, I think 181.1 is a venue statute, and that's undisputed. The Supreme Court has told us that it is. And if there's a facial challenge that's properly raised, venue has to be moved from one part of the General Court of Justice Superior Court Division to a new place for determination, because that's the legally correct place under statute. So Gardner, I think, squarely applies to this new situation, because whether it was granted, whether the motion was granted or the motion was denied, either side would have a right to an immediate appellate review under that case. Its language is broad. It even says there's no doubt to the fact that whichever way the order goes, there's a substantial right there, and this court has expounded on that principle in the Desmarais case when it said, hey, venue can't be fixed later. It is a substantial right that has to be addressed before final judgment to make sure, and there's a lot at stake in this case, as to that reason about where the decision should lie, because it's a completely different test, right? And that's why we also, have bootstrapped with our petition for writ of certiorari, in case this court thinks that might be an appropriate way to bring review up here. And that provides an alternative ground for immediate appellate review as well.
And you've got a little over a minute before you eat into your 5 minutes.
Yeah. There's an additional ground, I think, to explain why we've raised an as-applied challenge, only with respect to 117E. And that has to do with when you read all these statutes in pari materia, 117E was designed, we say, to revive claims only against a criminal defendant whose conduct resulted in the conviction that's referred to.
Statute says a defendant, not the defendant.
I think it does, but the trigger, the mechanism that triggers that statute is the criminal conviction. And when you read all the statutes together in pari materia, assuming there is an ambiguity, which I think it's fair to say that there may very well be, is that this is the only statute that talks about a criminal conviction. So if you're not dealing with a defendant that had a criminal conviction, then you can rely on the 2-year catch-all. Or if you're a minor, you can rely on the up to 28 statute. But it's not surplusage in there. This statute was meant to address only with respect to the criminal defendant to constitutionally apply.
Wouldn't the legislature use the word "the" instead of "a" if that were the case?
I don't think so. I think it's an open question. I think focusing on one word in the statute doesn't take away the ambiguity that exists in the statute. And when you read them all together, I think the more specific statute applies to a more specific set of cases. And the only point, Judge Carpenter, is to say we're only challenging the statute as applied to a non-criminally convicted defendant in this case. So that's just an additional ground for why we say it's an as-applied challenge. But the main as-applied challenge argument is that our rights had already vested because the existing statute of limitations had already run, and therefore rights vested under the North Carolina Constitution. But there are other defendants out there and plaintiffs out there who are going to litigate cases where the plaintiffs were under 21 at the time, and therefore it's not a revival unconstitutionally as applied. It's a constitutionally applied extension, at that point. So for the reasons articulated in brief and here in oral argument, we respectfully request that this court hear this important venue appeal based on the substantial right test, or otherwise, under our petition for writ of certiorari, and reverse and remand the case back to the Superior Court judge in Forsyth County for disposition of our Rule 12b-6 motion to dismiss on the merits of the as-applied constitutional challenge.
Thank you. We're from Appellee.
Good morning, and may it please the court. I am Bobby Jenkins, and along with my colleagues Don Higley and Lisa Lanier, we represent the plaintiffs in this case, a group of men who, as young boys, purportedly under the care of the Kernersville YMCA, endured nightmarish sexual abuse at the hands of an employee of the YMCA. It is clear from the defendant's argument that this appeal is based on venue in name only. The decision that they take exception to is Judge Gottlieb's decision that this was indeed a facial constitutional challenge and not an as-applied, even though they asserted it was as-applied.
Now, do you construe his order as transferring all of their arguments under 12b-6 to the 3-judge panel?
No, sir. Judge Gottlieb in the hearing clearly understood exactly what he was permitted to do under the statute. If I may show you, it's in the transcript. It's a transcript at page 22, and I have highlighted the portion. This was in the hearing, and Judge Gottlieb notes the statute says that everything that is subject to the challenge goes to the 3-judge panel, the challenge being the constitutional challenge. Anything not challenged stays in the venue from which the challenge came. Every aspect of this case, if plaintiffs prevail on this argument, will take place in Forsyth County. Motions, summary judgment motions, the trial itself will take place in Forsyth County. The only issue that Judge Gottlieb transferred was the facial constitutional challenge, which he, by both 1-267.1 and under this court's decision in Holdstock, had an obligation to determine. We did not have to make the motion to transfer. The statute authorizes Judge Gottlieb to transfer it sua sponte if he determines it is as applied.
Was the defendant's motion to dismiss before the trial court judge, or was just only your motion to transfer to the three-judge panel? Was that the only matter that was before the trial court judge?
No, the 12B6 motion to dismiss was before the judge, but he first heard our transfer motion, because if he determined it was facial, then he had to, under 1-267.1, because exclusive jurisdiction over a facial constitutional challenge to a act of the General Assembly resides with a three-judge panel.
Could the judge still consider them their as applied challenge, or you're saying they didn't make an as applied challenge?
Well, I'm saying they couched it as an as applied challenge. We contended that.
Well, I mean, they did couch it. Why is it a facial challenge if there's this class? I mean, if I breach a contract with you 5 years ago and the statute of limitations is 3, and the General Assembly in their infinite wisdom decides to increase the statute of limitations to 10 years, I might say, well, that's not fair to me because the statute had long run. But I wouldn't be arguing that it's not okay for, if I breach a contract tomorrow with you, that you would have 10 years to sue because the statute's now in place. So isn't that what they're arguing? Why isn't that not an applied challenge? Because they're saying it doesn't apply to anybody that might in the future have hired somebody that would have committed these terrible acts.
Because our position was, Your Honor, and we believe that if a court at any level invalidates that provision of the Safe Child Act as being unconstitutional, it will invalidate that provision as to anyone who is attempting to bring a claim under it.
Even if somebody is abused tomorrow and then wants to sue 20 years from now. See, I mean, I think their argument is once the old statute run, it's run, and that's why they've been treated unfairly. But they're not arguing that's the basis of their claim, like in my contract claim, is the statute's run, so you can't pass a law to revive it to somebody that's run. But we're not saying that I wouldn't be saying that you couldn't pass a statute for a future breach of contract. So aren't they just limiting it to that class of people where the statute had already run?
Except, Your Honor, I think the problem is that the only person, in our view, who would ever rely upon this within 2 years of conviction to bring a claim is somebody whose statute of limitations is otherwise expired. And so to invalidate, the legislature in the Safe Child Act also extended the disabilities period for these claims.
But this is the new statute of limitations. So if somebody's abused tomorrow, they have the statute of limitations that they would be under would be the new one, which would give them 3 years of breach of majority or 2 years or whatever after the person's convicted. So it's not reviving it as to those people. I'm just trying to understand how their class isn't limited to at least people who in the past were the old statute had run and they weren't subject to this new statute. Because now people are subject to the new statute.
But we still have a statute of limitations now that limits the disability to age 28. We also have what they would contend is a statute of repose. Somebody 20 years down the road, that statute of limitations will have expired, and the argument will be that they had a vested right at that point not to be sued, and you can't be sued now under this provision that relates to 2 years since.
So you're right. So there is no. You would say there is no as applied challenge still to be considered by Forsyth County because they didn't really make an as applied challenge.
Correct. Even though they, couching it as an as-applied challenge, I think is like the lipstick on a pig thing. You can call it what you want. You can do what you want with it. It's still. Yeah. The other issue, Your Honor, quite frankly, is that Judge Gottlieb's decision that it's as-applied is not immediately appealable. That's why they couch this as a venue argument, because both under 1-267.1 and Holdstock, there is no right to immediate appeal.
If you sue me and I move for 12B6 and I make no facial challenge, I have the right to have my 12B6 motion heard in that venue. That would be correct, I guess.
If you don't raise a constitutional challenge.
So if you say, hey, Judge Dillon raised a facial challenge and the trial court judge agreed and sent the entire 12B6 to the three-judge panel, I've now lost my right to have my motion dismissed considered by the trial court judge. It's got to be considered under Rule 42 by this three-judge panel. Why wouldn't that be a venue change that would affect my substantial right to have my legitimate 12B6 arguments considered if I really didn't make a facial challenge?
Well, Your Honor, if you filed a motion to dismiss pursuant to 12B6 and did not raise a constitutional challenge, did not mention a constitutional challenge, then there's no basis for any trial judge to determine
But what
that
if,
there's
but what if the trial
constitutional-
court judge incorrectly determined you did make a facial challenge, and I'm not only going to send that challenge to the three-judge panel, I'm going to send all your theories to the three-judge panel, which they can do under Rule 42 if I did make a facial challenge. But if I did make a facial challenge, now I've lost my venue to have my legitimate 12b6 motion. Let's say my defense really is the contract wasn't in writing, it's a sale of land. And I just want that, that's my only basis, but somehow the judge messes up and thinks I'm making a facial challenge. Now I've got to have my statute of frauds defense determined by a three-judge panel pursuant to Rule 42. Don't I have a substantial right to have that statute of frauds argument determined by the Forsyth County judge where I brought my action if I didn't make a facial challenge? And can I appeal that immediately? Because now I've lost my right to have my statute of frauds argument decided in Forsyth County because this trial court judge incorrectly thought I made a facial challenge.
Respectfully, Your Honor, I would say I don't think the question you're positing applies to this scenario.
No,
because
it's hypothetical. You're saying that
there was a constitutional challenge raised in this particular situation, and that was the only basis for the 12b6 motion, is that the assumption was that the statute applied to them, the revival statute, and therefore they argue that it's unconstitutional. There's no question the statutes and limitations for these men had expired under the old law. The question is whether it can be revived, and they contend that it cannot, and they raised the challenge. They just called it as applied.
So, counsel, would the denial of subject matter jurisdiction be a substantial right?
They have not been denied subject matter jurisdiction.
Well, I didn't ask you whether they have or not. Listen to my question. Is the denial of subject matter jurisdiction a substantial right?
I don't think it is for the purpose of immediate appeal. Your Honor, the best evidence that this is is a facial challenge is the fact that 2 days from now, Mr. Higley and I are calendared to have a scheduling conference with a three-judge panel appointed by Judge Newby that is there are two cases that have been referred, two different sets of lawyers, defense lawyers. And that three-judge panel will decide the exact issue that is before the court in this case, the exact issue.
And these are older plaintiffs. They're older plaintiffs where the old statute had already run before they enacted the new statute.
No, I say it with such exactitude, Your Honor, because one of those cases, the plaintiff is Michael Taylor, who is also a plaintiff in this case. The only difference with Mr. Taylor is that the pedophile abused him both at the Kernersville YMCA and at the Piney Grove Volunteer Fire Department. So that case is against the Piney Grove Volunteer Fire Department. The defendants there raised the exact same constitutional challenge. Judge Gottlieb sent that, as he did this one, to refer it to a three-judge panel that has now been appointed and is going to schedule the process for hearing the case. They did not contrive some venue argument and appeal the case because Judge Gottlieb's decision regarding the facial challenge is not immediately appealable. And so the other case is a different set. It involves an expired statute, and in the same situation, they did not contrive a venue argument so that they could come to the Court of Appeals or attempt to come to the Court of Appeals because the determination and it was Judge Ridgway who made that determination, that it is a facial challenge that needs to go to the three-judge panel, they accept that because it's not immediately appealable. And again, as I said, the decision they take issue with is the determination of a facial challenge, and yet that is not immediately appealable. If that was immediately appealable, that would have been the nature of the appeal.
Well, I guess, counsel, let's stop for a second. And looking at, Judge Gottlieb's order, it's a little thin on some findings of fact. So help me understand how we get from the plain language of as applied in the motion to the judge's reasoning to determine it to be. I understand, lipstick on a pig, I've seen some cute pigs with lipstick on them at county fairs across this state in my home county, so can't deny that there's lipstick. So let's take what lipstick's there, and I'm asking you to address that lipstick as your analogy, that it's in the motion. You can't deny that. So how did the trial judge get past the black letter of the motion to facially challenged in his order? Help me with that.
I will, Your Honor, and let me, in the hearing, the way the hearing went, Your Honor, was Judge Gottlieb, our motion to transfer was there. And Judge Gottlieb said, I need to hear underlying argument on the constitutional challenge to decide whether it's facial or as applied. And he spent probably, 2+ hours. He was incredibly patient, let us make every argument on both sides we needed to make. And at the end of that, then the next day, he determined that it was a facial challenge and he was sending it forward. And I'll show you in the transcript at page 34, Your Honor, get that straight. He says, he asked the defense counsel, Ms. Gunter, if you call it an as-applied challenge, but I conclude that it's really, doesn't matter what you call it, it's a facial challenge, I am required to either a motion or sua sponte to transfer it, meaning to a 3-judge panel. And she said, if you conclude it's a facial challenge, it should be transferred. Now, she went on to argue that it wasn't properly raised, which again, we take exception to. But the statute tells him, if somebody just says this is unconstitutional and doesn't characterize it, it is his obligation, both under 1-267(1) and this court's ruling in Holdstock, it is his obligation to determine whether it's a facial challenge. Again, he could have done that on his own motion, but we filed the motion asking him to consider this. If he makes that decision that it's a facial challenge, at that point, the defendant has no statutory right to venue over that question in Forsyth County. The only venue issue that is immediately appealable, and Judge Dillon, they cited your case for the your opinion in A&D Environmental Services for the general proposition that a statutory right to venue is immediately appealable.
So is denial of what someone perceives as proper venue, are you conceding that that statutory challenge is a substantial right?
Will you repeat that question, Your Honor? I'm sorry.
The challenge to what is claimed to be a statutory right to venue, which is how they phrased it, but a right to what someone claims to be their proper venue, do you deny or say that is or is not a substantial right?
What I would say is, if we had argued that venue was supposed, that they had raised a facial challenge and venue was supposed to be in Wake County, that's a given. That would have to go to Wake County to a 3-judge panel. In this case, Your Honor, I would contend that venue is peripheral. 1-267(1) gives the exclusive right to a 3-judge panel. That is the judicial entity that has the authority and the only judicial entity that has the authority to address a facial challenge and rule an act of the General Assembly unconstitutional.
Where does a 3-judge panel sit?
Wake County.
It sits in Wake.
But it's the 1-267(1) is really a subject matter jurisdiction. And if you look at our motion, despite what they say erroneously in their brief, 1-82 and 1-81.1, the venue statutes, never mentioned.
I think I'm following. So let's assume that they had asserted 2 defenses. Their constitutional defense, however, whether it's applied or facial. And then let's just assume that we have charitable immunity. Let's just say there's a defense, an affirmative defense. And because the judge transferred if the judge transfers the entire 12B6 to the 3-judge panel, and the 3-judge panel rules on both theories, and then it gets appealed, and our court says, you know what, that was never a facial challenge to begin with, does the 3-judge panel's ruling on the charitable immunity get kicked out because of lack of subject matter jurisdiction? Because they only acquire subject matter jurisdiction to consider the other theories if there's a valid facial challenge before them. You would say that, right? Because
Yes.
Okay, because you can transfer the entire 12B6 motion if there's a facial challenge as part of it. So if the Court of Appeals ultimately rules there really was no facial challenge, then I guess you're saying that's when you deal with if it, if it really wasn't as an applied challenge all along, this isn't the time to consider it because it's not really a venue issue, it's a subject matter jurisdiction issue, and we would just say, no, it really was an applied challenge, therefore, that's why we're going to kick out, if after the three-judge panel rules. You're making a subject matter, you're saying it's a subject matter jurisdiction issue.
It is as to their, what Judge Gottlieb concluded to be a facial constitutional challenge. It is. And that in our motion to transfer, we cite 1-267.1 in Rule 42. We don't even cite the venue. There was no argument about venue because venue, again, is peripheral. It is determined. It is set once the facial challenge decision is made by the trial court judge. We knew venue. We filed the case in Forsyth County, anticipating they would raise a constitutional issue, but you don't have to anticipate that. You wait for them to raise it. They raised it, couched it as applied, and then we made this motion, and Judge Gottlieb made the decision. Rule 42, as I read it, Your Honor, allows the trial judge to send to the three-judge panel the 12B6 motion. The other Rule 12 motions would stay in the county of original venue. It is not clear from the statute or from Rule 42, and it was not addressed in Holdstock, what if there is more than a constitutional challenge raised in that Rule 12B6. My interpretation of the rule is that the only Rule 12 motion in which a defendant can raise a constitutional challenge to an act of the General Assembly is Rule 12B6. Everything else it's the Rule 12B6 motion, and there are other reported cases from this court where folks have raised a constitutional challenge via 12B6. It's not the most well-written rule, but to me the clear intent is that the legislature recognized that either in a answer or in a Rule 12B6 motion a defendant could raise a constitutional challenge that is facial. If it had not given the trial judge the opportunity to send the 12B6 motion with the constitutional challenge to the three-judge panel, it would undercut the purpose of the legislature. The intent of the legislature in 1-267.1 is clearly to not have individual judges around the state ruling acts of the General Assembly unconstitutional, but to make it what I call a quasi-appeal, to put it before a panel, to have it fully aired and fully briefed, which may not happen at the trial court level.
So transferring, your argument is a trial court judge's order transferring a matter to a three-judge panel in Wake County is not transferring venue, but it's just transferring to the proper forum, I guess.
Absolutely.
So you're saying that's not a transfer of venue, even though it's moving from Forsyth to Wake County. It's like,
Right.
It's just a totally different type of court that has the jurisdiction to consider.
Yeah, that's because it's the legislature had to have a three-judge panel sit somewhere, right? And so they said Wake County. Everything else is Forsyth County. If we prevail and this is ruled constitutional, then it will go back to Forsyth County. Now, I'll concede it would have probably been easier if the legislature had simply allowed the trial judge to certify the case to a three-judge panel instead of this transfer process.
And an appeal based on the fact that subject matter jurisdiction that's not a substantial right, which personally seems a little bizarre, but I think this case law would probably support that.
And I think that was in our, we filed the motion to dismiss in the supporting brief.
People raise sovereign immunity or governmental immunity based on personal and subject matter, and I think the Supreme Court's always said the personal is immediately appealable, not subject matter, for whatever reason.
And again, that is why we're here purportedly on a venue issue, but we're arguing about the decision as to where subject matter jurisdiction lies, is because there's no appeal of that, and there was no argument about venue at all, ever in the entire.
Has a petition for writ of certiorari been filed in this case, or is this appeal based on substantial right? Is that the only theory?
To my knowledge, Your Honor, right?
And you can answer that in rebuttal. I'm just curious. Okay.
All right. So again, the constitutional issue, Judge Gottlieb clearly passed on that. He heard argument on it. Once he heard argument, he decided it was a facial constitutional challenge, and then did what he understood he had to do. If you read his order, this idea that he sent the entire thing, the entire matter to Wake County, if I can find it, is simply not borne out in his order. I think it's on page 125. Now, he does have a typo, plaintiff. He says plaintiff has asserted facial challenges. That should be the defendant to the constitutionality of acts of the North Carolina General Assembly. The challenges. So he just refers to facial constitutional challenges. He says the challenges must be heard and determined by a three-judge panel in Wake County. Now, he does in the last paragraph go on to say this action. But as I showed you from the transcript of the hearing, he clearly understood his authority and his limitations under 1-267.1. And in this order is clearly just attempting to send what he deemed to be a facial challenge to its appropriate place, which is a three-judge panel to be appointed by Chief Justice Newby, which again has, in two other cases, has happened.
So you would say those two paragraphs are sort of ambiguous, but as a matter of law, we should interpret that to mean, based on the context of the hearing, that he's not transferring the entire action, he's just transferring this one issue.
Yes, Your Honor, because I think he made that clear. The order itself is where he is sending the challenges. He
does say this action, so there's some ambiguity. I mean, you got to concede that. But so at least it's ambiguous, but you would have us construe it as a matter of law that he's not transferring for a jury trial before the three-judge panel once.
Right, because as Judge Carpenter said, he did not have that authority under 1-267.1, and I think based on the transcript, he recognized that he did not have that particular authority.
Judge Gottlieb did not include in his order a mandate that the remaining portions of the matter be stayed pending the outcome of the three-judge panel, which would have made it very clear. So the three-judge panel, as I understand, has already been appointed. Is that correct?
Yes, Your Honor. It's I was going to submit that in the calendar to the court as a supplement, but in reading the rules, I couldn't satisfy myself there was a basis to
right. Let me ask you a specific question. The three-judge panel has already been appointed by order of the Chief Justice in this case. Is that correct?
Not in this case, but in a case that addresses the exact same issue raised by this case, which is Michael Taylor, the same claims against, essentially the same claims.
Did the defendant in that case appeal the ruling as the YMCA has done here?
No.
They haven't appealed it, so okay.
Neither defendant appealed it. Once they made an as-applied challenge.
But we're not bound by anything in that case, I would think. There's nothing that's binding in that case because they didn't. Or is the YMCA bound by the fact that the other defendant didn't appeal? Why would they be bound by that?
They're not bound by that, but what I would...
Or why are we bound? Well, yeah, we're not bound by it.
Well, I think what it demonstrates, Your Honor, is that there is not a genuine basis for appeal because there's no venue issue.
So you're pointing out as persuasive, kind of. I understand.
Right. And we, at this point, would reserve the remainder of the time, Your Honor. If that's, I know you said you would stop us if.
No, you don't get you get 30 minutes.
All right. Okay.
You can keep rolling.
That is essentially concludes our argument, unless the court has other questions. Mr. Higley, would you like to add? We've still got 5 minutes.
Welcome.
Please, court. Thanks, Your Honor, for recognizing me. I do think that I should take my senior resident Superior Court Judge Cliff Everett's advice and shut up if you can't improve on the silence. I think this court is on it, and I think that the only thing that I would add is that I was the person who prepared and filed a motion to dismiss the appeal because I do think this is a clearly interlocutory appeal that does not affect a substantial right. And the court is already on both the practical and the actual problems that our friends on the other side have. It's a catch-22 for them. This is merely a transfer of the subject matter of a constitutional challenge to a three-judge panel in Raleigh, appointed per statute, that the legislature, if we take a step back and think about it, the legislature appointed this statute for judicial restraint. They drafted this, they enacted this statute so that one judge out in Watauga and one judge in Whiteville can't be making two different activist arguments about a facial challenge.
So you're saying if Judge Golub got it wrong, and this is an as-applied challenge, there's just no right to appeal it right now because it doesn't affect a substantial right, because it touches on subject matter jurisdiction, not on venue. Okay.
Exactly.
That's the appellate jurisdiction argument. Okay.
Exactly. And substantial right is, obviously this court knows that you on substantial right, you'll pick up 5,000 plus cases, and it's a case-by-case basis. And this is precisely the case for the court to look at the definition of a substantial right, which is where a plaintiff loses something forever that they can never get back, like a jury trial in their home county.
But this particular issue, is this a case of first impression as far as whether or not this is a venue challenge or substantial or subject matter jurisdiction challenge?
Yes, there is no case reviewing this statute in this context. It has been found to be very constitutional where it comes to jurisdictional challenges in other cases. This is the first time that somebody comes up with an as-applied challenge in a civil case in this manner. But for the good of the order, there is a hearing Friday where a three-judge panel is going to be deciding the same thing. That's exactly what the legislature was talking about when they enacted the statute. Get it all in Raleigh to a three-judge panel. Make it fair because somebody comes from each zone of our great state, and let that decision be made on this, whether this act is unconstitutional or not. And I thank you, and my mother thanks you for you allowing me to get on camera, and we'll rest with that.
Thank you. We'll hear a rebuttal. And you have about 4 minutes.
Thank you, Judge Dillon. You're correct. We have filed a petition for writ of certiorari with this court as an alternative means to review, and we think that exceptional circumstances in the interest of justice would
So you
warrant.
have filed, okay.
We have a detailed petition, and this court has examined 4 grounds for why certiorari is appropriate. 1, the subject matter jurisdiction is important and significant. I think we're undisputed that exists here. It's an issue of first impression. I think we just covered that too in several respects with this case. The order should affect numerous individuals and corporations. We've got 9 plaintiffs in here, and they're dealing with a particularly sensitive subject matter, and the defendant corporation as well. The need for the efficient administration of justice also highlights the need for immediate appellate review, because the federal district court, Judge Flanagan, has stayed a federal case pending determination, the ultimate determination of this case on the underlying constitutional issue. And I think our friends on the other side have said, well, this is just the venue interpretation. But you need to, if you want, in the interest of comedy and federalism, you want to at least understand that Judge Flanagan is waiting for this court and our judicial state system to deliver a authority on North Carolina constitutional law that the federal court's going to use. And it stayed the case waiting for it. So we need to make sure that this was decided in the right place, to make sure that we don't have a Holdstock situation where you're 4 years later down the road and then the appellate court determines, oh, well, this was all done wrong, and then everybody needs to get back to the starting line. And I think, Judge Gore, to your point about why certiorari is warranted in this case, assuming that the court doesn't want to address the substantial right analysis in our favor, is that the court should defer to the party's presentation of the issue. And as I pointed the court to the record. And we've done that in our motion to dismiss. And in our brief, we've cited a United States Supreme Court case for that point. It's the Sineg-Smith case. And we submit that this state should follow this Supreme Court of the United States guidance on this point of the party presentation rule, which is the court needs to rely on the parties to frame the type of constitutional challenge and rather assign courts the role of neutral arbiter. And I think you heard a concession from our friends on the other side that this is the statutes of repose and limitation had squarely expired. And it's a vested rights challenge only with respect to our client, where those vested rights had expired, and a ruling on the 12b6 would not affect any other class of defendant and plaintiff where they're making a challenge to the SAFE Act provisions at bar when the statute of limitations and repose have already run.
So logically, let me think about this. We have to first determine, is this a venue argument or subject matter jurisdiction? If it's venue, it's probably before us. If it's not, then we got to make the determination, do we grant your writ of certiorari? And if so, if we do, then we got to decide, then we can look at the order to determine if we think it's an applied, if your defense really was an applied challenge or facial challenge.
Correct. And I
Okay.
think argument today
That's sort of the logic we have to go through. Okay.
has confirmed that it is an applied challenge because a 12b6 order on our motion.
But
would
we
not-
don't get there unless we
would-
determine either it's a
Correct.
venue or
Correct.
we grant your writ. Okay.
But finally, part of the writ of certiorari analysis is there merit to the underlying appeal? That's a critical inquiry of the certiorari analysis. Is there merit to the underlying appellant's issues? And there necessarily is, as established today, because we're not asking the trial court to make a constitutional ruling as to the SAFE Act provisions that are challenged with respect to rights that had not vested where the statute of limitations had not run. So for those reasons, we respectfully request that this court here, under either substantial right or cert, reverse and remand to Forsyth County. Thank you, Your Honors.
Thank you for your arguments. We got one by WebEx. So we'll adjourn court because we have one more argument today, but by WebEx. So.
Adjourn, Your Honor?
Yes.
Okay. All rise. Sure. The session of the Court of Appeals is now adjourned.